Yes, let's proceed.
Thank you. Good morning. May it please the Court, my name is Kathy Zeal, and I'm the General Counsel for the Massachusetts Commission Against Discrimination. The primary issue today is whether the Superior Court properly entered a declaratory judgment and permanent injunction barring the Commission from proceeding with a Chapter 151B administrative process on a discrimination complaint that had been filed by Ms. Gay Hilsenrath, a part-time lay teacher in Temple Emanuel's Sunday and after-school program, where Ms. Hilsenrath alleged in her complaint that she was terminated or not her contract was not renewed after 24 years as a teacher because of her age. Temple Emanuel filed a motion to dismiss at the MCAD and submitted some papers in support thereof, arguing that the very inquiry into whether, into the reasons behind its decision not to rehire Ms. Hilsenrath were barred by the First Amendment.
Isn't that correct? That's the whole point. You can't inquire to why a religious institution takes certain actions. Isn't that the whole protection that's provided?
It's a protection that's provided to ministerial employees that are deemed ministers under the Hosanna Tabor case and the cases that have been decided under the ministerial
Your position here is that
application.
this is just related to ministers, not those who are engaged in the mission of the church by teaching children.
Well, my position is consistent with what the Supreme Court has says, which is the law of the land, of course, and that is that in that case, the court held that the ministerial exception is adopted. It applies to the heads of religious organizations, to priests, to rabbis, to ministers, and to other persons as well, and in that case specifically applied it to a commissioned, and said further that it could apply to people that are below, the head of the church, head of the minister, and applied it to a commissioned minister, a woman who.
But she was a teacher. I mean,
she was a teacher whose primary duties were teaching lay subjects, but nonetheless, because of the nature of her other duties, which were involved leading prayers, religious ritual, and because she had been held out by the Lutheran Church through a very detailed commissioning process that was engaged in by the entire congregation, and had a significant religious education as well, and there were a number of other circumstances of that nature. She took the clergy exemption for tax purposes.
So if this job involved teaching the Talmud or teaching the Torah, would you concede that that would be a ministerial position?
Your Honor, how that would be resolved at the MCAD, as the process proceeded, the MCAD has dismissed cases for First Amendment
but I wanted
purposes.
to ask you that. Did you do discovery when you did that? Did you do discovery on those specific issues that relate to the First Amendment?
What happened at the commission is that the commission was unable to. Well, the commission typically a complaint is filed, it's reviewed, it can be dismissed for lack of jurisdiction right on its papers. Here, the commission did what it normally does. It requested a position statement, which is an answer, and also sent out a request, an investigatory request. It's not discovery. This is the commission investigating whether or not it can make a preliminary determination as to whether or not to go forward, probable cause, lack of probable cause. And in this case, the motion to dismiss was filed, and ultimately the case in court before the MCAD was able to do anything essentially in the case. And excuse me, excuse me, when the MCAD has had before it a complaint that on its face implicates the ministerial exception, for example, in the Callahan case where a pastor was suing his church for discrimination, it dismisses the case. It's dismissed.
Let's take a step back. What is the ministerial exception designed to protect? Isn't it designed to protect the decision-making of the religious institution? And what you're saying is we want to know why you've made this decision. Then we're going to decide whether you're subject to the religious exception. Isn't that backwards?
I think that, well, the investigating commissioner can choose to do limited inquiries with respect to that. It does so for jurisdictional issues and certainly could do so on the affirmative defense. Limited investigative inquiries. However,
it's like the attorney-client privilege saying, well, we want to know what you said to each other, then we'll decide whether there's a privilege.
I think that there are significant factual questions about whether the ministerial ministerial exception applies in this case. Just look at
But
the
you have-
federal courts.
I'm sorry, I just said, that's a different question, whether the ministerial exception applies. You don't look to why they fired her, or why they didn't hire her for the new position. You know,
That would be so, if
Don't you think-
indeed we were able to conclude as a matter of law that Ms. Hilsenrath was a minister, was a rabbi within the meaning of her.
What facts are in dispute about this?
Well, the problem is that there was no factual record that was developed, because all the MCAD had in its record was the complaint, and the motion to dismiss filed by Temple Emanuel. Ms. Hilsenrath we submitted an affidavit on her behalf to the court. So there was a minimal factual record before the
Undisputed
court.
that she's a teacher, and then that's not disputed.
She is a part-time lay teacher.
But she's a
She
teacher.
claims that she was, in her affidavit, that she was never
Okay.
called a religious teacher, that she never taught.
Well, regardless of the name, there are certain things she taught, and that's not disputed.
No, it's difficult for me to say whether or not, well, she disputes that she taught, based on her affidavit, she disputes that she taught kids, prepared them for their bas or bar mitzvah. That is in her affidavit. She, again, disputes that she was ever called a religious teacher. She asserts that the Temple Emanuel filed ads on Craigslist seeking a teacher who knew Hebrew, and a number of other things. But these have not come up through the discovery process. These
And
are
it's an after-school program, and it's
they're
not
adversarial documents on both sides.
right. But it's an after-school program. It's not designed to replace, as a private school, public school, general education. All those things we know.
Well,
Just because you focus on rabbi, and the Hosanna case doesn't focus on the ordination part. It focuses on if you can categorize an employee whose functions are essentially essential to the independence of the group and are entrusted, for example, with teaching and conveying tenets of faith to the next generation.
That's correct, and the Hosanna Tabor case makes clear that it's teaching the faith. And if I could just point the court, in our reply brief in particular, to look at some of the cases where these are whether the question about lay teachers is a highly factually intense post-discovery involving summary judgment kind of situation. And when the court while the court is not directly involved in the discovery process, it's nonetheless state involvement. And we know the First Amendment ministerial exception is an affirmative defense, so there is going to be inquiry into this area. And I also would ask the court to look at those cases for the reason that there are no situations. The idea of teaching is teaching the faith. So when that exemption, based on that piece of it, is applied, it's been applied to, for example, a nun who taught at the Catholic University canon law to people who were going to become leaders of their religion. It's been applied to, if you would just let me grab my notes on this, there are a number of cases. It was applied to an individual at a high school who taught only something akin to canon law under the particular religious, given the nature of the religious school itself. It's not been applied to people, and it's also been applied to individuals who, as I said before, lead prayers, who engage in ritual. There's a case that's cited in our brief, involving an Orthodox rabbi who was responsible for the Washington Jewish homes, the Washington case, for making sure that the dietary laws were followed, which is an extremely important aspect of Judaism, and who took that tax exemption, who engaged in ritual. And there was, after discovery, after summary judgment, a conclusion that for FMLA purposes, where they applied the ministerial exception in the same way as under Title VII, that he was indeed a minister for purposes of a minister, which for purposes of whether or not he was entitled to overtime that he claims he had not received.
So what kinds of discovery do you think you were entitled to that was not intrusive on the Temple's First Amendment right?
Well, I think that what we need to do is, in light of Hosanna Tabor, issue a set of questions that are consistent. The investigating commissioner would issue, or on her behalf, limited inquiries that were consistent with the kinds of factors that were considered important, not only in Hosanna Tabor, but also in looking at the cases below, when those kinds of factual determinations have been made in the various circuit courts. And some of the things that are looked at are what were the qualifications for the job? Was there a religious background that was required? Was the individual, there's a host of questions that we have guidance from the courts in the various decisions that have been made and cases that have gone forward as to what sort of what would be.
And that's not the way you pursue.
I'm sorry. No, that's probably the same question. In this case, did you say here, we're not going to get into whether or not there was discrimination. We're going to address this very first issue as to whether or not the ministerial exception applies, and we're going to limit discovery to that issue. We're going to decide that issue, yay or nay. Is that what happened in the MCAD with regard to this case?
What happened is that the motion to dismiss was denied without prejudice when it was filed before any investigation whatsoever had taken place. And the investigatory requests did ask about the employment, the employment decision.
On the discrimination issue. They were all focused. The questions had nothing to do with this ministerial exception.
As I said, I think that the questions would be refashioned in an effort to determine whether or not, as a matter of law, whether or not a lack of probable cause determination would be appropriate, because if, as a matter of law, the investigating commissioner can determine that Temple Emanuel is entitled to the affirmative defense, then it would issue an
But
LOPC as
did they
opposed to
say
an
we're going to
LOJ.
bifurcate? I mean, probable cause could have two elements. One is the person fits within a ministerial exception. The second is there was no discrimination.
That's correct.
Did you basically say we're going to take this as a preliminary issue, we're going to not deal with the discrimination, we're going to resolve that issue when it was denied without prejudice, or simply was it denied without prejudice, and then everything was discussed, including whether or not there was discrimination?
I can't speak for what the thinking of the investigating commissioner was. I can say, however, that that the motion to dismiss could have been raised after some information, even.
Okay, but I guess my concern is, and I think this may be what Judge Cordy is asking, essentially, if you begin to go into the inquiry of whether there is discrimination, don't
Yes.
you, before you've decided whether or not the First Amendment kicks in, haven't you essentially then lost your right to, I mean, I understand your position, but it seems as if your position is going to be what it is. You have to define this issue, yay or nay, and then let that issue be appealed to the Superior Court, as opposed to saying, no, we're going to decide the entirety of the case.
But in this particular case, we're almost 4 years out from when the complaint was filed, and I think there's a certain degree of prejudice also that has. I think that Ms. Hilsenrath has experienced in us being in this position now, and to bifurcate. I think the idea of bifurcation is certainly an appropriate one, and the commission in cases where a determination can be made at any point. Quite frankly, the MCAD has many points at which a case can be dismissed because affirmative defense is determined to bar, continuing, including on the LOPC initial determination, during the next phase on a motion, and of course the adjudicatory proceeding. And the MCAD is sensitive to First Amendment issues and will establish some focused interrogatories to deal with that when there is reason to believe that that will bar the continuation of the complaint process. But you have to remember that asking the questions isn't a constitutional harm, and the U.S. Supreme Court has said that in the Ohio Civil.
There's no constitutional harm to be making an inquiry of, let's put aside this case, if it were a rabbi who were being fired, you would say there'd be no constitutional harm in demanding that the temple explain the reasons for the...
I wouldn't say it in that case, because it's a matter of law. That is the law.
But that's
It was the law before and after
But
Hosanna
it's
Tabor.
when you say questions, don't you mean asking the First Amendment jurisdictional questions?
Well, I'm going by the Civil Rights Commission, the Ohio Civil Rights Commission case where this issue was raised by the Lutheran, by Dayton Christian
Schools.
School. The issue went before the U.S. Supreme Court, whether or not the Superior Court should have, the Federal District Court should have exercised jurisdiction over the case filed by the school claiming that the First Amendment rights were being violated by the Ohio agency doing
Really
a
a younger
discrimination.
decision in the end of
Excuse
it.
me?
It was really an 11th Amendment Younger v. Harris decision at the end of the day.
It was raised as a comedy issue, and the comedy being comedy to the state administrative proceeding, which is, and finding that in the context of state administration proceeding, that the First Amendment rights would be protected so long as there was a fair adjudicatory process and the right to judicial review. And I would argue that the same applies here.
But I hear you saying that you're entitled to conduct discovery on the question of discrimination, and then the issue of the ministerial exception is essentially an affirmative defense.
I'm not saying quite that. I think in the aftermath of Hosanna Tabor, we know the kinds of questions that we need to ask in order to flesh out the affirmative defense, and that is what will happen in these cases because we're required to do so, by the U.S. Supreme Court, and we have guidance from those other decisions we know what to look at. The same way that through discovery in the federal courts, those issues were fleshed out. And as a general matter, if that can be done in an expedited fashion without prejudicing the parties by a limited inquiry, that's the way that the investigating commissioner has the discretion, can certainly act in that way. Here, the interrogatory, they're not the requests, the investigatory requests, need to be revamped in light of the decision. And need to focus in on some of the First Amendment issues, but it is an affirmative defense, and we do have the Ohio Civil Rights case, which says there's no harm in the investigative process itself. We have no interest in doing, in doing freewheeling kinds of investigation where ultimately it is determined that the First Amendment bars the case.
Okay, but it sounds as if you are reserving the right and the discretion of the hearing officer to make inquiry into the issue of discrimination before the hearing officer has decided the First Amendment issue.
If the investigating commissioner, you're talking about before the hearing?
No, I'm saying that you are
order of
essentially
issue.
reserving the hearing officer's right in his or her discretion
Yes.
to make inquiry into the issue of discrimination before the hearing officer has decided the First Amendment issue.
Reserving the right to exercise that discretion. That's correct, because there are cases that the further you get away from what the court said in the Hosanna Tabor case with respect to clergy, and then persons like Ms. Pelich, who are commissioned ministers, the more factual it becomes.
Let me
And
interrupt.
as part of the process, I'm sorry.
Your time is up.
Okay.
Sorry. I want you to finish your thought,
Oh.
but we can't just go on and on.
Okay. I was going to say, if the facts of the claim of discrimination are inextricably bound up with the jurisdictional issue, I would like to reserve, the Commission would like to reserve the right for the investigating commissioner to exercise discretion on whether to go forward on the full case or bifurcate it.
Thank you.
Thank you.
Good morning. May it please the court, Tom Carey for Temple Emanuel of Newton. Hosanna Tabor has clarified many of the issues in this case. And in particular, I want to address Christian Dayton schools, which we heard again a moment ago, which was a linchpin of the legal position of the MCAD.
It's not cited in Hosanna Tabor, as far as I could see.
Yeah. No, it isn't, but it's rejected. If you give me one moment. If you take page 18 of the MCAD's brief and the argument they made on Christian Dayton, and the specific sentence that they quoted about we can look into the reason, that same argument, same quotation, was argued by the Solicitor General for the EEOC in the Hosanna-Tabor case at pages 38 to 40. And they also argued on page 42 the Gary and DeMarco cases relied on by the MCAD, all of which address the idea that there's no constitutional violation if we investigate the reasons. It was rejected here, page 20 of our addendum to the sub, and it's page 20 of Chief Justice Roberts' opinion. The EEOC and Parrish suggest that the asserted religious reason for firing was pretextual. That suggestion misses the point of the ministerial exception. The purpose of the exception is not to safeguard a church's decision to fire a minister only when it was made for a religious reason. The exception instead ensures that the authority to select and control who will minister to the faithful is the church's alone. That was our position.
Do you agree, however, hypothetically, that the question whether a particular person fits within the ministerial exception or not is a factual determination to be made?
I certainly agree that whether you're within the exception is a decision to be made. I don't think it's purely factual. No.
Does it have facts in it?
It certainly, every legal ruling applying the law to the facts of a case has facts in it.
And are you saying that the commission is not entitled at the first instance to make a factual, forget the discrimination?
No, we're not saying it. We never said it. We never claimed below to be above the law. We filed a motion to dismiss, raising the exception, the ministerial exception. We provided an affidavit for the rabbi. We gave them everything about what this position was, and we gave them all the law that we said we think establishes that we are covered by the ministerial exception. Denied. No reasoning.
I understand that. I'm just asking hypothetically.
Oh, hypothetically, the MCAD has power to decide cases brought before it alleging violations of the employee discrimination laws. And they can take those cases just like district courts can take the Hosanna-Tabor case. Once they get them, if an issue is properly raised and facts are presented demonstrating that the ministerial exception may apply, I think the thrust of footnote 4 and the entire thrust of Hosanna-Tabor is you must first decide the issue of the exception before the claimed case on the merits can proceed.
Okay. But
that's all we asked them
all right,
to
well,
do.
Let me just ask you this, though.
Sure.
Okay, under footnote 4. Let's assume, I mean, the EEOC is in court, obviously. Let's just take that example. EEOC brings this case in court. There is a proceeding in which summary judgment is sought, denied. The judge says, you're raising a lot of good things, but there are facts in dispute. You get to have a trial on this issue about whether the ministerial exception starts. Okay, there's a trial. The judge finds that on those facts, my judgment is no ministerial exception. Do you say that there's then an interlocutory appeal that can be brought? Or is it possible that you have a trial on the merits and then both issues are preserved on appeal?
We say that the best way to deal with these cases going forward, and the way we think it ought to be dealt with, is to recognize that ruling as one immediately appealable under the doctrine of present execution, even as updated to yesterday's Marcus opinion, because this is effectively a claim of immunity in the same way
It's
that
a
the qualified immunity of the police officer. Hosanna Tabor doesn't, I think, leave any doubt that you're protected against the government coming in and trying you. It's not simply a merits defense that's somehow mixed in with the employee
But on
claim.
that point, let me just ask you that, though. On that
Sure.
point, the fact that the court doesn't do anything with respect to saying, we overrule Ohio Christian OC, whatever it is, Ohio Christian Academies, the
Well,
David schools, doesn't say that. So I guess I'm just wondering, why is that so certain? Why isn't it enough that you have that factual determination if the fact finder finds the ministerial exception does not apply in this, that's my judgment, or that's, so I'm going to go ahead and reach the merits. You're going to have the right, before you have to do anything, you're going to have the right of appeal to a higher court, and therefore, it's not like, it doesn't qualify for the doctrine of present execution.
Yeah, the premise of your question, I submit, is wrong. There was no occasion to overrule Christian Dayton because Christian Dayton never said what the MCAD or the EEOC was claiming it said. And the opposition filed by Doug Laycock representing the school made that crystal clear for the same reasons we gave in our original brief. It's a younger case. It says don't interfere. It overturned any decision on the merits by the two judges below. It said you shouldn't have even gone in there.
But it has language about the fact that in the state court,
it has-
there's going to be
yes.
the appellate rights, right?
Yes, oh yes. But that language, again, is younger language. That language is, we have often said we rely on the state courts to ensure that their own procedures are going to be adequate. And we won't listen if you complain that they aren't because we know they will fix it. They're pitching Dayton Christian two reasons. One is they say it tells you what power your judges have over state administrative agencies. It does no such thing. It talks only about federal. Second, they're reading a younger decision to give a view about the scope of the ministerial exception, even though the district court judge said there was no ministerial exception in the case, and even though the Sixth Circuit didn't think there was. The judge in the district court said if I thought it was ministerial exception, I wouldn't allow you to interfere. So there was nothing to overrule, but that pitch that the substance of the ministerial exception is subject to the government's power to inquire into whether a religious reason was the basis for the dismissal or whether a pretextual reason has been given, that argument is just flat out rejected in Hosanna Tabor, and it can't survive.
So let me understand. You say that after you submitted your motion to dismiss with the affidavits, and there was a ruling denying the motion to dismiss, that essentially at that point the record was sufficient for you to appeal on the preliminary issue, and you should have been permitted to do so.
At that point, yeah, well, yes.
There was no additional fact-finding that MCAD could have legitimately engaged in on the subject.
We said, is there anything more you want? We'll give it to you. They said no. We got single-word denials, including a denial of a request to appeal to the full commission. So it was everything denied. In that situation, as many, many cases in Massachusetts establish, we went to the Superior Court seeking a declaration of our legal rights. And in that declaration, we asserted the facts necessary to decide this issue of ministerial exception are fundamentally undisputed.
Are they really undisputed?
Yes,
Based
they
on
are.
the contrary affidavit of the former employee on
Yes.
this issue?
Yes, they are. Now, with the following...
Undisputed that they're undisputed?
Pardon?
I didn't read the MCAD's brief that way.
No, of course, the MCAD doesn't think they do, but
Well, okay, then it's- then
the
there's a-
district court judge did
Well,
think
but
so.
I understand that the Superior Court judge thought that. But that's really, the question is whether or not the MCAD could go back and have a factual hearing. If there were facts in dispute, presumably there could be an evidentiary hearing
Correct.
to determine whom to be believed.
And the judge said, I'm willing to do that. The reason I provided the supplemental appendix of the argument before the Superior Court judge, and in our brief I cite the pages where this exchange takes place, you can see that the Superior Court judge was probing, well, why do you need all of the stuff on the merits? Is there something you can just ask about this? Would you do that? And it was a stonewall, that's not our
But that was
procedure.
before Hosanna Tabor, too.
It was, but, and also...
So the question is what to happen now.
Well, yes, I agree with that. I would beseech you not at this stage to throw me back into that briar patch, which I really don't want to go into. I believe that as you look at this record, you will conclude all the facts needed for this decision are present, and you're fully capable of rendering a decision on the meaning of the First Amendment without a remand to allow an agency which still doesn't even want to read the decision as precluding their inquiry into the reasons why the employee was fired from having another go at this. You know, they came in with
But to
the
do that,
affidavit of the...
to do that, don't we have to find that based on what the teacher, Ms. Hilsenrath's affidavit says, that even if that is true, you're still entitled to the relief?
Absolutely. And we made that argument. We presented it to the trial judge below. And at pages, I can supply them with you if I can't grab it off the top of my head. In the appendix, there is an attachment which has a table comparing the facts in the rabbi's affidavit and the facts in Ms. Hilsenreich's affidavit. Right down the line, each and every one of them. The essence of all the areas that the rabbi addressed, she objected to four. The objection was, for one, the rabbi's declaration of what the essence of being a rabbi is, I don't agree with. I don't think that raises...
So being a rabbi or being a teacher?
Being a rabbi, because he said being a rabbi involves this, and teachers are doing similar work because they're the epitome of Jewish values in the classroom. She says, I don't think teaching Hebrew is religious. She's teaching sort of, my tribe's terminology, CCD students, not parochial school, to get ready for confirmation, which sounds like one half a dozen of the other. Of course, somebody picks them up in the last year or two to walk them through the ceremony, but all that learning in these religious schools being held in the temple itself is directed toward knowing the prayers. She was actually teaching the prayers as part of her duty, that's uncontested. And you can't do that in this religion without some understanding of Hebrew. And so that conclusion sounds to me more like it's a conclusion of law as to what's religious for purposes of the exception. I submit to you that when you read the whole record in this case, and you look closely at the lack of dispute of the factors that are relevant, there is no factual dispute. You have enough to decide. And Hosanna Tabor has clarified most of it. All that's left is whether you read Hosanna Tabor as limiting this ministerial exception only to people who hold a clerical position, our clergy or ministers. And in all fairness, I suggest, though Roberts wrote a very tight opinion and said, on our first effort, we're only going to deal with the facts of this case, the opinion is replete with information that someone like this employee who was transmitting the message of the church and teaching its prayers to the next generation is covered. And certainly Alito and Kagan, concurring, are adamant on that point. You don't need a religious title. And there was no pushback against the concurrence from the majority. So going forward, I believe you have enough. I hope you will decide in light of the plea for both parties. Decide it now because no more is needed. On the issue of how to deal with these cases going forward, I think that the opportunity to repair to the Superior Court under the declaratory judgment, if in fact what the agency comes up with is not an appropriate way to deal immediately with the claim of the exemption, is the appropriate way to go.
Thank you.